Good afternoon. Welcome to the Heritage Foundation and our Lewis Lehrman Auditorium. We, of course, welcome those who join us on all of these occasions on our heritage.org website. I would ask our guests here in-house to be so kind to check that cell phones have been turned off as we prepare to begin. And, of course, we will post the program on the Heritage homepage following today's presentation for your future reference. And our internet viewers are always welcome to send questions or comments simply emailing speaker@heritage.org. Hosting our discussion today is Andrew Closter, who is our legal fellow in the Edwin Meese Center for Legal and Judicial Studies. He focuses on civil rights, the role of the federal courts, and other constitutional issues. Before joining us here at Heritage, he was the Justice Robert H. Jackson Legal Fellow at the Foundation for Individual Rights in Education. He has also worked on Capitol Hill and with the Human Rights Organization at the United Nations. Please join me in welcoming Andrew Closter. Andrew?
Thank you very much. So in late 2013, news broke that Target Corporation had been hacked, compromising the credit and debit card records of 40 million, what we now know to be 40 million customers. This March, a federal judge approved a $10 million settlement by Target to end a class action lawsuit arising out of that event, and class counsel are expected to recover up to $6.75 million of that. In November 2014, Sony Picture Entertainment was the victim of a hack, which involved much personal information about Sony employees, including some embarrassing industry gossip. The hackers demanded that Sony not release a film, The Interview, which satirized North Korea. The list of high-profile incidents of commercial hacking are numerous. Health provider Anthem, Home Depot, Staples, Adobe, Citigroup, and more. Much of this involves consumer data, but some is more serious. For example, the FBI is currently investigating a story that just broke this week of Denver security expert Chris Roberts, who claimed to have taken control of over a passenger aircraft mid-flight by hacking the aircraft's entertainment system. He claims to have temporarily caused the aircraft to fly sideways. All of this is to say that cybersecurity is a huge issue, and it is an open question how the United States will handle this growing risk. There are numerous options. Should we be hands-off? Will consumers be able to make informed market-based choices on their own? And can industry self-regulate? There is some evidence for this, as many web email users are starting to shy away, for example, from Google and choose maybe European-based emails in order to come under EU privacy law. Further, industry has developed information sharing on its own to some extent. Is this adequate? And on the other hand, can consumers make informed choices and choose one airline over another based on the investment the airlines have made in cybersecurity? Maybe not. Option 2, should states, and particularly state tort law and state consumer protection agencies, handle cybersecurity? Is there a duty of care to consumers that is violated when companies fail to adequately protect data? Is it unfair that company A can save a few pennies per data process if it secures its servers less than company B? And finally, option 3, federal involvement. Should Congress pass a cybersecurity law? What might it look like, and what constitutional authority is there for such a law? Alternatively, is there a federal agency to do the job? In the past decade, the Federal Trade Commission has pursued over 50 enforcement actions against companies that it has deemed had, quote, inadequate data security practices. The theory generally relies upon the FTC's Section 5A1 Unfair or Deceptive Acts or Practices Authority. These include cases against Twitter, LexisNexis, ChoicePoint, GeneLeak, LabMD, hotel chain Wyndham Worldwide, and mobile provider HTC. Many of these cases settled, creating a so-called common law of FTC data security standards. Is this good? Is there another agency out there that can do a better job? The Department of Homeland Security, perhaps? Do we want a TSA for what Vice President Al Gore once called the information superhighway? Commercial cybersecurity regulation is hugely complex, involving questions of institutional competence and the pitfalls of over and under regulation. So we're fortunate enough to have three distinguished experts today to help us explore this subject. So I'll introduce our three panelists, and then they will each have about 8 to 12 minutes to talk, after which we'll have hopefully a fair amount of questioning of the audience. First of all, we are delighted to have back the Honorable Maureen Olhausen. Commissioner Olhausen is a sitting FTC commissioner, and she was sworn in 2012. Prior to joining the commission, she was a partner at Wilkinson Barker Nauer, where she focused on FTC issues, including cybersecurity. She's a graduate of George Mason School of Law and the University of Virginia. Next, we will have Paul Rosenzweig. Paul Rosenzweig is the founder of Red Branch Consulting, which is a Homeland Security company. He formerly served as Deputy Assistant Secretary for Policy in the Department of Homeland Security. He's a contributor to the Lawfare blog and is a lecturer or adjunct at George Washington, the National Defense University, and Northwestern University. Mr. Rosenzweig is a graduate cum laude of the University of Chicago Law School, the Scripps Institution of Oceanography, and Haverford College. And finally, we will have speak Phil Goldberg. He's a partner at the Washington, D.C. office of Shook, Hardy, and Bacon, LLP, where he focuses on liability-related public policy, including related to data security and privacy. He has testified before numerous state legislatures, filed amicus briefs in state and federal court, including the Supreme Court of the United States, and is a graduate of the George Washington University Law School and Tufts University. So without further ado, please, Commissioner.
Well, thank you so much for that nice introduction, and to Heritage for having me today. This is my second event at Heritage in the last few months, so I hope you will all enjoy having me here as much as I enjoy visiting. I'm particularly glad to be here today to talk to you about the important topic of data security and to engage in a discussion with my fellow panelists. But to give you the usual disclaimer, of course, my remarks are just my own and not those of the Federal Trade Commission. Now, securing important data is a major challenge, and this has important roles and responsibilities for numerous stakeholders, including industry and consumers and government. And there's no one-size-fits-all data security program. Indeed, there's no such thing as perfect security. It's reasonable security, and it requires a continuous process of assessing and addressing risks. And too much of a focus on technical solutions and checklists will fail to keep up with the reality of ever-evolving attacks. So the fast-developing data security world demands that regulators act carefully, recognizing the limits of their ability to predict and prescribe what private actions will most effectively protect companies and consumers. And that's why I believe the FTC's case-by-case enforcement of data security, when executed with a strong dose of what I like to call regulatory humility, and integrated with our policy initiatives and business and consumer education efforts, provides a valuable backstop to private data security efforts. Now, given our consumer protection focus, the FTC primarily views data security as a subset of privacy. So security, broadly speaking, is about how entities safeguard assets from unauthorized access. And data security is a subset of security concerned with protecting data assets from unauthorized access. Many different types of data may be involved, and this can include trade secrets, proprietary financial and business plans, and consumer data. Because the FTC's goal is to protect consumers, we focus on likely harms to consumers. And consumers' biggest data security concerns are breaches that involve unauthorized access to sensitive consumer information, such as financial or health data. Now, for over a decade, the FTC has promoted data security in the private sector using a variety of tools, including civil law enforcement, policy initiatives, and business outreach. And these tools serve different but complementary functions, and I'd like to talk a little bit about each one. So the FTC enforces data security requirements that are imposed by a number of statutes, including the Fair Credit Reporting Act, the Gramm-Leach-Bliley Act, the Children's Online Privacy Protection Act, as well as enforcement under the EU Safe Harbor Authority. However, the FTC primarily enforces data security under its Section 5 Deception and Unfairness Authority. And in many cases, those other statutes that I already mentioned characterize violations as being Section 5 violations. Deceptive practices are explicit or implicit representations about material facts that are likely to mislead consumers acting reasonably. Now, companies make statements to consumers in their privacy policies or elsewhere, sometimes directly in their advertising, about how they use and secure consumer data. And the FTC holds those companies to their promises. If a company makes a promise that a consumer reasonably relies upon and the company fails to keep that promise, the FTC can bring a deception action against that company. And the Commission's Unfairness Authority does not require representation to consumers, but instead focuses on the consumer harm that an act or practice may cause. So a practice is unfair if it causes substantial harm, which is not outweighed by any offsetting benefit to consumer or competition, and that the consumer could not have reasonably avoided. And the Commission has specifically identified financial, health, and safety as varieties of harms that are substantial. And it's further concluded that emotional impact and more subjective types of harm will not make a practice unfair. So using its unfairness and deception authority, the FTC has brought 55 cases against companies with significant lapses in data security. And the touchstone of our data security enforcement is reasonableness. A company's data security measures must be reasonable in light of the sensitivity and volume of consumer information it holds, the size and complexity of its data operations, and the costs of available tools to improve security and reduce vulnerabilities. Using this approach, the Commission challenges practices that are unreasonable in light of the full range of circumstances. Now, we don't impose strict liability for a breach, and I also think it's fair to say that none of our cases have been particularly close calls. Now, we close many more data security investigations than we bring, and we don't investigate every breach, because that would be hundreds each year, but usually do some kind of research into the particular facts of a breach to evaluate it. And for many, and I stress many of these matters, we do not proceed to open a formal investigation because, based on publicly known facts or other information, further investigation is not warranted. And for matters where we do open a formal investigation, we end up closing somewhere around 2.5 to 3 investigations for every one that's brought to a complaint or settled. Now, we close some of our investigations because, upon further inquiry, we find that the company's security is reasonable or even good. Now, in other cases, we find that there was a significant security failure as to one particular aspect or issue, but we don't believe that the overall security program was unreasonable. We don't typically bring cases challenging a company's security practices as unreasonable based on a single failing. Our cases nearly always involve multiple failures in a company's overall security program. Practices the FTC has found to be part of such systemic failures include transmitting sensitive information such as login or payment information in clear text without SSL or other encryption, storing sensitive consumer information on unsecured laptops, placing unencrypted consumer health information on publicly accessible websites or services, and enabling unsecured access to streaming video feeds from internet-connected home security cameras. Now, I don't believe that any of these were particularly close calls. They are careless practices well outside industry norms, and they are the types of practices the FTC has and should continue to focus on in its enforcement efforts. Now, the FTC's enforcement actions undoubtedly have an educational effect because they publicize particularly egregious and systemic failures of security. However, for emerging technologies and business practices where industry best practices haven't yet been applied or established, the FTC can use its convening authority to bring stakeholders together and thus help foment the development of best practices. And the FTC typically does this through workshops and reports. And these efforts simultaneously help educate the Commission while providing a forum to identify and discuss key issues and potential solutions. So, for example, the Commission's Internet of Things workshop in November 2013 highlighted the potential data security problems in Internet of Things technology. And our subsequent IoT report that came out earlier this year captured recommendations from the workshop on how to implement reasonable security by, for example, conducting risk assessments, hiring and training appropriate personnel, and monitoring access controls. Now, the Commission also seeks to directly educate businesses and consumers about good data security practices. So, for example, we widely distribute a business guide on data security and a related online tutorial. And these resources provide diverse businesses, particularly small businesses, with practical, concrete advice on developing data security programs. And in the coming months, the Commission will launch its Start with Security campaign to provide small and medium-sized businesses with resources and education and guidance on data security. In addition to general business-oriented materials and basic data security, the FTC develops data security guidance for specific industries. So, for example, the FTC has crafted specific guidance for mobile app developers and data security guidance for tax preparers and human resource professionals. The FTC also offers educational materials on specific topics, such as the security risks associated with peer-to-peer file sharing programs and companies' obligations to protect consumer and employee information from these risks. And further, the FTC recently released guidance on data security for Internet of Things devices. And the Commission also reaches out directly to consumers. And so we have sponsored our On Guard Online, which is a website designed to educate consumers about basic computer security. And On Guard Online and its Spanish language counterpart, Alerta en Linea, average more than 2.2 million unique visits per year. And the FTC makes available a wide variety of other consumer educational materials to help consumers deter, detect, and defend against identity theft, which is one of the biggest consumer concerns in the data security area. So, for example, we have our new Pass It On education effort, which is aimed at older adults, people who are 65 or older. Now, identity theft has been the top consumer fraud complaint to the FTC for 13 consecutive years and is undoubtedly the most significant consumer data security harm. And the Commission has just unveiled an enhanced and streamlined identitytheft.gov website, which provides consumers who may be victims of identity theft with important information and tools to protect themselves and assist in the recovery process. So that's just a little bit about what the FTC is doing in the data security space at this time. And I certainly look forward to our discussion about how we can better meet these important challenges in a way that protects consumers and the businesses that they rely on every day. Thank you.
Unless you object, I'm going to stay here. It's much more comfortable to sit than to stand. There's much to admire in the FTC's engagement in cybersecurity. The idea of education of American citizens, the development of best practices and standards are all things that are absolutely essential for good cyber hygiene and almost certainly a value add in government engagement. I would submit, however, that before we rush forward to happily embrace the idea of federal regulation of the reasonableness of cybersecurity standards, we step back and ask whether or not federal government engagement is the right tool and whether or not there might not be better ways of achieving the same objective. This is not to critique the well-meaningness of anybody in federal government, but those who practice in the area know that the Federal Information Management Security Act was a well-meaning effort to enhance security within the federal government and has kind of devolved into a checklist that doesn't foster security in the same ways that we had hoped it would. And there's reason to at least be skeptical of the idea that a large federal bureaucracy of any sort can keep pace with the mutating security requirements of the cyber domain. A brief note just on the law before I kind of, since Andrew and I are both lawyers, we're all lawyers, right? Yeah. In 2000, the FTC's general counsel sought expansion of the unfair practices statute to cover cybersecurity, because at that time they were of the view that, as written, the statute did not encompass the authority that the Commission has gone forward to exercise ever since. Whatever you sort of think of whether it is or isn't there, it is at least notable that this expansion of the Commission's activity has taken place against the backdrop of its, admittedly dated perception that it wasn't part and parcel of its capabilities. But I think the more fundamental question, which is a broader one, which is whether or not we want to see an enforcement regime managed by the federal government or the FTC, or a portion of the federal government, based upon a reasonableness standard of behavior. That is not a standard that is defined in regulation. You must maintain X, or you must in terms of cybersecurity, or you can only pollute up to Y limit, but rather a judgment after the fact about whether or not the activities that the company is accused of were reasonable. And I don't think, with respect to the FTC, that it's any defense to the theoretical discussion to say that thus far we've always been right and that our cases are not close. I'm actually willing to agree that thus far the discretionary authority has in most instances been exercised quite well. But the question I think that is more germane is whether or not that kind of discretion is the sort that is not subject in the long run to arbitrariness, capriciousness, expansion, all for all good reasons, but nonetheless not generally how we do things in a regulatory environment. Indeed, the only other area I can think of where we talk about a common law of regulation is in the antitrust field generally, right, where the rule of reason has developed over hundreds of years. And that's a useful counterexample because it does establish that in some instances we can come up with a broad common law that is not a formula for abuse. But in most instances, we look to our regulatory agencies and we require them to set forth hard and fast standards that we judge community behavior by, whether it's pollute up to 20 parts per million, or this is the wage and these are the notices you're going to provide in labor. So it is, I think, an unusual circumstance in which we choose a regulatory regime that is premised upon a discretionary standard that is deliberately chosen to be indefinite. Now let me pivot and say that I approve the standard. I actually think that asking the federal government to write a hard and fast rule about what cybersecurity is or should be right now is a mistake, because the rules that we would write today would not be applicable in 48 months. The domain space mutates. What is appropriate behavior mutates in an infinite number of ways, in ways that we can't frankly predict right now. The types of attacks that brought down Sony were ones that nobody would have anticipated 3 years previously. The methodologies, the precise ways, and just would not have been something that we would have seen. So, there's a sense in which reasonableness is the right standard because it requires you to keep up with whatever the contemporary best practices are. The question is whether or not it's a federal government responsibility, or my preference, preferentially, probably one in the state tort, contractual domain, right? That's traditionally where we see the development of common law standards of responsibility and liability developed. And I know one of the reasons that we're having this panel is that that's a bit of a heresy at Heritage to speak positively of tort lawyers and their role in regulating corporate behavior, and they come with their own disadvantages, to be sure, and their idiosyncrasies. But it is the story that Andrew told actually sort of speaks to it. Target's paying a $10 million judgment, not on an FTC enforcement action, but on a class action. If you ask me, 6.5 of that for the lawyers is probably too much. But that's a problem with the tort system, not a problem with the methodology. And it seems to me unlikely that the recent attention to cybersecurity in the C-suites around the country are the product of FTC enforcement, as much as they are the product of the fact that the CEO of Sony lost her job. And the company got hit probably on the order of $100 million in actual damages to their business. So my general sense is that for a number of years, companies disregarded cyber security, not because they were flying under the FTC's radar, but because consumers didn't demand it, and there was no liability for failing to do so. That's changing slowly, perhaps too slowly. But The settle point for me in the long run that I would kind of espouse is the development of a liability system that extends beyond liability for data breaches, which we've pretty much defined now, to consequential third-party liability for knock-on effects for cyber breaches that are reasonably avoidable, and with it, an insurance system that insures against such risks, that will also probably require a rating system so that insurers can grade risks and determine what, if anything, they should be doing. And I sometimes think that we need an underwriter's laboratory for cyber risks in the same way that they grade electric goods. And then, of course, there would come with it an audit and compliance function that would be kind of a third-party checking function. And in the end, a liability system that engages contractual obligations and tort obligations as well. There are barriers to that. Things like the economic loss doctrine probably are limits to tort liability, and it'll probably appear more in the contractual domain than in the tort domain. But I would submit to you that none of the answers that Andrew offered are ideal. None of them are going to get us to a perfect space, but that the least bad option is one that engages the private sector, private ordering of rights and liabilities and responsibilities, rather than one that relies as its enforcing methodology a government enforcement standard, which is ARM, which is not to say, to circle back to where the government doesn't have a role. NIST has put out a wonderful cybersecurity framework that is a great baseline for good behavior that would, in my model, form a definition of what a reasonable person might be required to do in a tort domain. That would be a good way to go forward. That would engage the federal government by having it help jumpstart liability. But with respect, I sort of am not of the view that a focus on cybersecurity through the lens of privacy, which is another piece, which is the unique focus of the FTC, is the right way to go. And I'll pass onward.
Thank you very much. Phil?
You're going to stand up?
Yeah, well,
Okay.
there's an American flag there. It's hard not to want to stand in front of it. Well, thank you both for those presentations. I know I learned a lot just listening to you guys, and so I appreciate that. As Andrew said, my name is Phil Goldberg, and I'm a partner at Shook Hardy & Bacon here in D.C., and Victor Schwartz, one of my partners, is in the audience here, so I certainly want to acknowledge him and a lot of the work that he's done in this area, and certainly tort law generally. Our job and sort of where we come at this is trying to work on the development of the liability side, which Paul said is probably the least bad, and I would probably disagree with that characterization of the liability side. And our focus is really to go where those liability decisions are being made. And the positive law that the commissioner is talking about happens in Congress and federal agencies and to some degree the state legislatures. And they're focusing on what the government response should be to regulate this area of the law. But the common law is decided in the courts and is decided either in the federal or the state courts. And so we get involved in trying to educate courts through judicial education seminars, talking to them directly through appellate briefs and amicus briefs when issues like this, where that's so novel, or at least perceived, frankly, to be novel. I don't know how novel they actually are. We can talk about that in a little bit. To help people give context to what the law ought to be and kind of how the liability decision should be driven. The truth is, and the reason why there's such a major concern right now is because almost everywhere we go, whether online or in person, data is being collected on us. And it's something that, especially in the wake of some of the high-profile breaches of the past year or so, has really grabbed the fancy and grabbed the attention of the policymakers. And so if there is a breach, depending on some of the factors that the commissioner laid out, you may get a knock on the door from the FTC. But you're most certainly going to get sued in the tort system. And the question, sort of the fundamental questions of, what are you sued for, by whom, and for how much, are fundamental questions of liability law, yet here they remain completely unanswered. And and the reason is because we're sort of where product liability law was in the 1970s when it comes to data privacy, sort of at that, what is a defect, what is a breach, you can look at the parallels between the two, and perhaps Victor's probably the only one I know who could have foreseen, back in the 70s, 40 years to where we are with product liability and toxic torts and all that today, and we're trying to lay that foundation and figure out, what is the standard of care in a breach suit. I have clients who feel that it's a strict liability tort. It may not be strict liability from the FTC side, but is there a standard of care? They had whatever procedures in place to prevent the breach, and yet there's still a breach. Is there liability? Just like a product could hurt somebody, but if there's no defect, there's no liability. When is somebody injured? Here, there's remarkable parallel to the toxic tort system, where you have a breach, just like you'd have an exposure, and then there's this latency period where no one has been injured yet, and you don't know if anyone's going to be injured. And at the end of it, there may be people who are injured and may have an actual claim. And where the game really is now, and I'll talk about this in a few minutes, on the liability side, are the class action counsel are trying to monetize that latency period. How do they make that just the pure breach without necessarily injury, as we traditionally understand it? How do they make those claims viable in the tort system so that they can monetize that? And so when we figure out where these answers are going to come from, we look at several sources. We look at Congress and legislation, and on the liability side, it's unlikely that we're going to find real answers there. We can look at the federal agencies, the FTC orders, for giving us a sort of guidance as to how they interpret these key issues, but not necessarily that's going to be determinative in the courts. We look at state legislatures. There's 47 different state notification laws that all differ with each other, and so trying to work through that maze can be a challenge. And a lot of them have some impact on liability, but not as direct, frankly, as they could. And then the courts, and and one of the reasons why I think this is not the least bad option is because it's the courts create sort of a haphazard approach, jurisdiction by jurisdiction, and it's very hard to understand or anticipate ahead of time what your liability or what conduct you can engage in that would put you above the line, where you say that you abided by your standard of care. And so when we looked at the standard of care, I see three factors that are going to decide whether there is a standard of care that's been breached in an individual case. And one is what information we're talking about, so how personal identifiable information or personal information is defined. There's federal legislation that has some definitions. The FTC, through their orders, will have put a body of sort of FTC common laws to what that means. State legislation differs by state. Sometimes it has to be a person identifiable to that person, or sometimes it could be just information that could lead to identity theft. So like a password, even though it may not be identifiable to that person, it could ultimately lead to identity theft. And then the courts. And then the question is, well, when has a breach occurred? Well, sometimes is it at pure access, even though the person may not have acquired that information, or does it require actually the information being acquired? And there are distinctions in these various sources when it comes to that question. And then the idea that we were talking about before in terms of what's your obligation to have those the right enforcements in place, and it's reasonable security measures, and that's a typical common law concept that's highly fact intensive and not one that really gives a whole lot of guidance ahead of time. And so, as the commissioner said, that is sort of this no one size fits all. You've got to get into the details, which is what, frankly, facilitates expensive litigation, is when you have to get into the fact-intensive details. And so, from the class action counsel's perspective, they try to leverage this uncertainty and the high costs of the litigation to generate, and frankly, business pressures like publicity and all that to generate settlements, and also increasingly being hired by state attorneys general as under contingency fee counsel. And there's an increasing movement, not only for the state AGs to get their authority to pursue companies through their own notification or own state law, but also as an alternative to enforcing federal law and federal standards. And so where I think sort of this nets out in what the FTC decides to do, what Congress decides to do, there's not going to be any express preemption of state tort claims, certainly that I see coming down the pike. If you're looking at implied preemption, it's highly unlikely. It's been pretty much disfavored at the Supreme Court level, even when you have such highly prescriptive regulations. And here, where it's so vague, that's not even. Honestly, I don't even really see a whole lot of regulatory compliance where the courts are going to say, you know what, we're going to defer to what the FDA decides on, what design, safe and effective drug, or we're going to defer to the federal agency on food labeling. I don't see that happening here because we don't know what reasonable is in a case by case. There's very little to point to. If the FTC has investigated and has, I'll use the word cleared for lack of a better word, a company, might that have an impact? Probably admissible as evidence in a case. Maybe, I don't say determinative, but maybe very influential if punitive damages are being sought, that they've been, said that they weren't violative of federal law. And so sort of at the bottom line on this, what the standard of care is, I think we'll get guidance from what the FTC decides. We'll get guidance from some of the federal laws, but the lack of specificity and the gives both counsel, plaintiff's counsel, private counsel, and AGs significant discretion and the opportunity for highly fact-intensive inquiries, which again drives up the cost of litigation. So where the game is being played right now in the liability side is in the damages side of the equation. Because the traditional rule is that if you don't have an injury, then you don't have a lawsuit. And in the federal court, it's typically seen as Article III standing proposition, and the Supreme Court case from Clapper a couple years ago sort of laid that out, and that's generally what the federal courts are following. And in the state court, if you don't have damages, your claim can be dismissed for failure to state a claim, that you don't have a tort claim against somebody if they haven't harmed you, even if they have breached a standard of care to you. And so with the private counsel strategy here, it's kind of like companies do research and development, that they try to figure out, how can we monetize this? How, what theories can we try? Which courts might be receptive to it? Atcher calls them judicial hellholes, where they're probably more receptive. Courts might be more receptive to some of these novel legal theories. And Victor has shared with me sort of his old adage that if a plaintiff's attorney can sue for people only for those who are injured, they can make a good living. But if they can sue for people who were never injured, they can certainly generate a fair amount of wealth. And so that is what the key question is. And if you look at tort law, you look at products liability, you look at the toxic tort examples, there's a lot of answers there. The problem is that, as I see it, and I think early on some courts did look at it in that context, but in the past couple of years, I think we're seeing courts be more willing to say, well, there was some injustice done here. We've got to figure out how to rectify that, how to give them, the plaintiff something because, the company did something bad or their information got out there. And, in the Target case, apparently some 16-year-old didn't have a good vacation in Paris because her debit card got canceled. And that would, are those damages that are achievable in a court? There's a federal district judge, Hamilton, who said that the unauthorized disclosure of personal information via the internet is itself relatively new and therefore more likely to raise issues of law not yet settled in the courts. But I submit to you that some of these issues are settled, just not in this context. And so if you look at how the plaintiff lawyers are trying to monetize the latency period, you can look at direct parallels to other areas of tort law. So, credit monitoring has a direct parallel to medical monitoring. You look at increased risk of future harm. It's been tried in the toxic tort context. Unmanifested injury, inconvenience damages, emotional harm, and then statutory damages when those all fall short. And when you get to medical monitoring, it's almost that first thing out of the box that everyone starts offering. But credit monitoring, but medical monitoring is not a broadly accepted concept and has been rejected by about half the states that have considered it. And the other half, most, have very tight guidelines. Increased risk of future harm post-Clapper, we thought that probably was going to sort of fade away. But in re Sony in 2014, the Federal District Court of the Ninth Circuit denied a motion to dismiss because the plaintiffs said had standing based on increased risk of future harm. And in re Adobe had a little bit more restrictive standard saying, well, at least the information there was out on the internet already. We know it was going to be misused, even though nobody could say, hey, my identity was stolen, I had these damages. That we know the intention of the hackers was to use that information for no good. And so those are post-Clapper cases that suggest that courts want to find a way to open up liability, or some judges at least want to find a way to open up liability here. The unmanifested injury defect, we're seeing actually a little bit of movement in that in the product space, in the washing machine cases, where maybe only some of the washing machines had the alleged defect, but all the purchasers are part of the class, and trying to figure out how to define what their injury is has been a source of significant dialogue in the courts. In West Virginia, you had the West Virginia Supreme Court said the breach of confidentiality and invasion of privacy claims need not allege special damages, so just the breach itself was sufficient. The inconvenience damages, and this is one that I don't understand, because this is common to any tort claim. You're in a car accident. You've got to call your insurance. You've got to bring your car in to get it fixed. You've got to do all these things. You don't get paid for that time. But yet, in the December ruling in the Target case, the judge presumably acknowledged that there could be payment for these types of these inconveniences that people had. And so, what is the impact of that decision? Not just in the data world, but to other types of tort claims? Because now all of a sudden, is that a compensable injury in other types of tort claims? Because is there a special law just for data privacy and not for other types of torts? I don't know that would be true. Emotional harm damages, the same thing as fear of cancer cases in asbestos and other toxic torts. And then sort of when all else fails, go to the statutes. So the Breach Notification Act will be one source where they'll go. The federal bill probably will not have a private cause of action. In 14 of the states, they do have private causes of action to enforce the Breach Notification Act. But you do generally, probably one or two states don't, require injury or actual damages to avail yourself of that. You have Consumer Protection Act claims, which is sort of a very common place to go, where if they'll point to the disclosure statements and said, the company said they were going to protect all of our information, and look, it got out, so that's a violation of the Consumer Protection Act claim in that state. And then one of the hot issues right now is whether just mere violation of a federal act is sufficient injury. And the Supreme Court just granted cert in the last month in the Spokio case to answer the question of whether the breach of the Fair Credit Reporting Act gives rise to an injury. And so that'll be something that we're going to look at in the next session. And so just sort of in conclusion, I think where we stand now on the liability side is sort of typical when courts feel like they're addressing a new area. You get a little fits and starts. Some places things get a little bit more receptivity. Other places they don't. Hopefully, at some point soon, there becomes sort of a body of law that people can kind of gravitate towards. There will be a few outliers, and whether those outliers are actually doors into a new path of liability or just sort of one-off cases is something that we won't know for a while. But that's what those who are bringing these cases are working hard and being creative. Doing as I said, their R&D on the tort system to figure out where they can open up new lines of their business for them, and it's up to us to try to make sure that we educate the judges and try to say this is how the law ought to be, because this is how the law has been in these other places, and these are direct parallels here. So with that, I pass it back, Andrew, and I thank you all for your time.
Thank you very much. So thank you all for those informative presentations. I'll ask the first question, and I think we have plenty of time for questions from the audience as well. So before we get to that, I'll just mention when you have a question, please have a question mark at the end and have it be sort of in the form of a question, and also please identify yourself. So I want to ask the sort of institutional competence question on these issues. So the FTC consent orders are not adversarial. They are not in Article III courts, and they're not always, as far as I'm aware, most of them do not proceed to conclusion. They're settlements, classic settlements. That's even further to the side of maybe what happens in the FDA context, where you do have APA even notice and comment, and that's certainly to the side of Article III tort cases where you have, or not Article III, state court cases where you actually have adversarial process and adjudication to the end. So my question is, in terms of institutional competence, what is there any sort of, and this is for all three of you, is there a bias in where these cases are placed, in the sense that maybe one type of system is more in favor of overregulation, maybe one is in favor of underregulation, maybe one favors sort of larger, is more capable of handling larger corporations with very complicated sets of facts, maybe some are more capable of handling small cases. So I'm asking, is there a one-size-fits-all strategy here in terms of where these cases ought to be placed? And is there maybe a bias in, if these things are handled at the state level versus the FTC versus other federal agencies?
So maybe I'll jump in first on that one. I think one of the things to keep in mind is the fact that, so the FTC has been enforcing using this statute, unfair and deceptive acts or practices, since 1938 in the Willard-Lee amendments. And it has been a very general and broad statute that has been used in a number of business contexts. So this is how we regulate advertising law. This is how we regulate a lot of marketing. This is how we regulate a lot of financial transactions. So we do have two statements that cabin how we interpret our deception authority and our unfairness authority. Now, there is a question, and I think something that Paul has brought up, is one system better than the other? And, or is the FTC system, when is it useful? When is it a good opportunity or makes sense for the FTC to step in? So a couple years ago, then Chairman, FTC Chairman Muris wrote an article called The Future of U.S. Consumer Protection Policy, which I was happy enough to assist him on. And one of the things that we looked at is, when is it appropriate for the FTC to step in? So we should have, market forces are sort of the first line of defense for consumers. So the other thing that the FTC does is antitrust enforcement. So I always like to bring that in. So is this the type of problem that market forces alone are going to be able to address? And generally, a lot of problems are able to be handled by companies competing against each other. But that isn't always the case when it's an attribute of a product that it's very hard for consumers to know about when they are engaging in the transaction, when they're sharing their information, right? So if a company says, I'm going to protect your data to this level, and they don't, okay, that would be kind of a market distorting issue if we didn't enforce it there. Or there could be, that's a typical kind of advertising enforcement deception that we do. But for unfairness, where there's a harm and there's been no representation, that's kind of hard for the market to necessarily take care of that, at least at the beginning, right? So eventually maybe a company will get a bad reputation and for their data practices, and consumers won't use them. They'll vote with their feet, and there'll be a reason for competitors to start to compete on that attribute. We're starting to see a little bit of that now. There's some competition on privacy that's going on. You see that in some of the handsets where they're saying we're going to encrypt our data more, and you can't get it. But it's still not a fully developed market mechanism. So then the other thing you look at is you say, well, why wouldn't tort law take care of it? So you have the question, if you have a small injury to a large number of consumers, which particular consumer has an incentive to actually bring the case, right? So that there's typically not an incentive if I'm the consumer who said, well, I can't really be sure. I think that my data got loose, and eventually I had identity theft committed against me, but I can't really put those two things together. So it's going, I think, some of the stuff Phil was talking about is the difficulty of coming up, of kind of tying those two things together. Certainly, we could have class action, right? So you do have class action as a way to address some of these, small harm across a lot of consumers, but class action is often not to be totally against class actions, but one may have questions about whose interest the class action suit really is in. Is it in the interest of the lawyers, or it really is in the interest of the harmed consumers? So for the FTC, I think we do have an appropriate role here, kind of going through those three-part steps of why the FTC is an appropriate actor in this space, because we do actually look out for consumer interests. And I will also say, we don't, in the data security area, we don't seek money, right, against the companies. We're not getting money redress. We're telling the company to fix its practices, and then we have fencing in, which requires them to take a broader set of steps. So my answer is, I think the FTC is appropriate acting in this space, but we should not be the sole actor. And I certainly think that having private suits and self-regulation and education be a larger part of the picture makes sense. But the role that we have been playing here is very consistent with the role that we've done in general business oversight, really, since we've had the authority since 1938.
I think your question, I'm going to divide it. One is kind of institutional competence, and the other is technical competence. One of the things that I worry about kind of fundamentally is that cybersecurity is a lot more than protecting privacy and a lot more than data breaches. And in fact, from a national perspective, the right way to set standards about cybersecurity is from the perspective of national security interests, foreign policy interests, privacy interests as well. I mean, they're an important part of it. But by driving cybersecurity standards principally now, I mean, the FTC is the only federal game in town, right, at this point, pretty much. The FCC is trying to get involved, and there'd be a nice little interesting hissy fight between the two FCs about who's going to take primacy. But we are distorting, I think, resource investments by advancing consumer privacy as the more important good than, say, the security of operational systems and critical infrastructure, which is, if it were up to me, that's where I would be putting our dollars and our focus and our interest. So institutionally, that suggests to me that the FTC has a role to play, but the dominant role that it's playing now is inappropriate. Then the second part of that, so that's the technical one. The second part of that is kind of institutional competence, and that just kind of gets back to my overarching idea, which is, the federal government's role is in addressing areas where there is a market failure. But the evidence, Ben Powell did a great study for George Mason Universities, but that at least in the financial industry, they're pretty much investing the right amount of money and more every day. J.P. Morgan just announced a $800 million initiative within, what is it, SIFMA, I think it is their the market forces are working. And we wouldn't expect them to be instantaneous in response any more than we would expect federal government to be instantaneous in response. So I worry that by focusing our efforts through the federal government and on only a particular subset of the problem, we are going to actually wind up coming out in the wrong place from a broader societal perspective. So that would be my answer.
I think the challenge here, to some degree, is, and I think you can look at developments with the Foreign Corrupt Practices Act enforcement over the past 10 years or 15 years, where you have this new area of federal enforcement. You have the discretion is entirely in the hands of the government agency who is enforcing the issue, and you have a governing community or governed community that isn't always sure what they're supposed to do and how they're supposed to, how they're supposed to make sure that they're operating on the right side of the law. And so I appreciate that what you're saying is, well, we're really looking at the low-hanging fruit here. I mean, that's where our focus is. And frankly, that's probably appropriate where the focus should be, because if there's clear violations, and maybe through that there develops some sort of body of, regulatory common laws, as it were. But there's been a lot of frustration, I know, within the industry, in the FCPA context, of trying to get, whether it's a compliance defense or self-reporting or things that they can do to say, hey, we're trying to partner with you to get this right, but yet they do that and then they're opening themselves up to penalty. As this goes forward, having the DOJ and the SEC about 2 years ago put out a really thick guidance book for people on FCPA to say, hey, here's where we're going, here's what we're looking for. Something like that, I think, would be very valuable for the FTC to put out, to something that was comparable to that. And maybe it's too soon for that as you're developing your own sort of regulatory common law. But I think trying to provide a little bit more guidance would be helpful so that the governed community knows what they're supposed to do. It knows what reasonable is.
I think we have time for questions. Yes, we have a mic coming.
Oh, sure.
Please.
Yes, Jose Colon from I work for the Department of State. I worry normally about national security, but I had a different question. The problem, as I see it, with the regulations on cyber, is one of consistency. The federal government is very large, and the interests of one agency are not the interests of another agency. In this case, I'm a technologist, not a lawyer. So I see this is a technological problem with technological solutions. However, the industry argues that the government is opposed to some of those solutions. For example, the director of the FBI has gone against, several times, against strong encryption. The industry argues will solve the problem. So I don't know if the SEC had a position on that, on the strong encryption. Similarly, today, several industry groups are the major players in the industry, Google, Facebook, etc., sent a letter to the president asking for the government to stop the policy of requiring backdoors because that weakens security. Doesn't that introduce an alibi for companies to say the government doesn't let me implement the best solution possible? That is.
Well, I signed that letter, so I'm on your side.
Well, I'm no side.
Oh, well, I'm on. I think that's an exact example of an appropriate market solution, right? And I also think that in the end, if the U.S. government mandates backdoors, it'll disadvantage American products in what is essentially a global market that can't be fractionated. So somebody will sell it in Mexico without the backdoor, or England, or wherever. So I agree with you completely. I won't speak for the commissioner, but I think the FTC has spoken in praise of encryption as a way of protecting consumer information, and they've sued people for not encrypting it. So there is a sense in which the FBI and the FTC really need to get their act together and talk to each other.
Well, we've certainly suggested that encrypting information is a good way to engage in data security, encrypting consumer information, but we're not a national security agency, right? We're a consumer-focused agency, so we don't have a position on the national security implications of some of these technologies.
And at least at the state level, I'd say well into the 40s number of states have encryption requirements for certain kinds of personal information. And so we're talking about the most sensitive information. There are still, there is a growing requirement to make sure that that information is encrypted. And I think New Mexico, they're hoping would join those this year, and unfortunately the bill failed. But I think it's like literally 47 or 48 states have encryption law requirements.
So I think I saw Paul back there, and then up front, and then I saw over here. So
Paul Larkin, the Heritage Foundation. Is business at a risk of just continually being subject to new forms of liability, whether it's from international bodies, international countries, or the different states, as somebody comes up with some new idea and they really have no fallback position that they think will provide them a long-term basis for deciding how much liability that they can face?
Well, maybe I'll jump in on that one because it's seemingly in my bailiwick.
Softball.
Yeah. Yes.
There you go. That's the answer. Just
You know, I think the piling on of liability, or you know, it's like you get hit by the feds, you get hit by the state AGs, then you have your class claims, and it seems that as soon as one thing happens, there's a cascade, there's a playbook of all you're getting hit from all these different places, and so yes, I mean, I think that if there was some more streamlined process, more way to deal with this, there are times perhaps when it really is just a regulatory issue and it ought not be a tort issue, when the nobody's information was misappropriated and used used wrongly or injured anybody, or when you've done all the things you're supposed to do, you had state-of-the-art compliance programs, security programs, then just because you had a breach, and does that mean that you now need to engage in even the target $10 million settlement, which may not seem like a lot, but that is a door opener, I think, to a lot more. And so I think we want to avoid sort of that knee-jerk reaction. I was on a panel the other day, and someone said before they even heard from the FTC, they had 3 class actions filed. And before they even, he said, and it was before they could even confirm that the breach had actually occurred internally through their own investigation. They had 3 class actions filed. So I know that you're asking people in the plaintiff side to do maybe what's against their self-interest by actually waiting for the facts to come out. But that would be nice if that would happen, so that we can actually deal with things in a prioritized, common sense, and appropriate way, and not just that knee-jerk reaction.
Question up front here. Can we get the mic?
Thank you. My name is Joanna Brignolo. I'm a retired federal worker.
Make sure it's a question, please.
Well, I was trying to introduce myself.
Oh,
So
sure.
that you asked, I usually wouldn't. But I am really, I'd like to know, you mentioned Target had a class action suit. Is there a class action suit underway with Anthem? I received a letter. I don't even know the name until I received this letter from March 27th, 2015, suggesting my information has been compromised, and it blew my mind. I don't know the name. I don't participate. I am a Blue Cross, a member, but I don't know this name. So I'm just aghast about this, and I'm just curious, what does a consumer like myself, who has no knowledge of this company, and I call Blue Cross, and I just don't understand it, and why are they sending this to me? So am I supposed to be doing something? I would like to know. That's why I came. Okay, thank you.
So I can't really answer whether there's a class action suit against Anthem, but I would direct you to the FTC's resources on identitytheft.gov that will give you some information about the steps you should take and what you should be thinking about to start to begin to address some of the questions that letter raised for you.
Sure. So, I apologize. When you held up the paper, I thought, oh, here comes a long missive. Okay, please, over there.
A former Heritage Legal Center intern. The panel has talked a lot about victims of cyber breaches, but I'd like to talk more about those that are not multinational corporations or consumers with like a tort lawyer on speed dial. For example, could the panel talk about, small political or charitable organizations or independent contractors, solar practitioners that are early in their career, or whistleblowers or investigative journalists, those people that there might be an incentive to discriminate against them for religious or political or some other reason, but are not, perhaps don't have the funds to protect themselves or to seek, redress in litigation, or have the funds to even just have the security features that a multinational corporation would be able to.
Well, Let me answer your question in two ways. The first one is if you're concerned about small entities being subject to large obligations to take data security protections, one of the things that we try to do is it's a sliding scale. It's based on the sensitivity of the information they have, but also their resources to engage in data security protection. Often we think about this as a big online kind of thing, but some of the basic steps that we've asked companies to take, small companies to take, are things like don't take sensitive financial information and put it out in the dumpster. We've actually, failure to shred things like mortgage applications. The FTC has asked them to do that. Some basic things like lock your file cabinets or ask who has access to this information among my staff and why do they have access to it. So those are the kinds of low-cost steps that we recommend. Now, I think your other question is if they are victims, right? If their information is being put at risk. I mean, I think that is one of the reasons why having a federal agency take some steps here, play some role, can be useful because it does. The goal of the FTC is to protect consumers more broadly in two ways. One, certainly for the people who are using that particular company, but two, to educate industry more broadly so that they know that they need to pay attention to these things. So some of the stuff that we did, for example, with TrendNet, which was this internet-enabled camera that had an obvious security flaw in it and allowed the live feeds from all these, anybody with an IP address to put that up on the website for everyone to see, babies at their homes and people in their houses. I think that is one of the useful things that the FTC can do with its consumer level focus rather than necessarily people who would need the funds and the sophistication to bring a suit on their own.
Well, I think our panelists have been very generous with their time, so please join me in thanking them for this informative panel.